friends, welcome to my channel. This is a girl Mercy. In this channel I talk about law practice, I talk about the life of a lawyer, I talk about tips for excellent practice, I talk about career path. Now today I'm going to talk about preliminary objection. If you're a returning subscriber, I appreciate you. If you're new here, please subscribe to this channel, like and share this video because it's going to help someone out there. Now, in considering preliminary objection, which is fondly called PO by lawyers, certain factors have to be considered. Now, as a defendant counsel, when the process is being served on you, you have to look at it critically. You have to analyze it, to determine, is this suit valid? Can I raise the preliminary objection? What are those points I can use to raise the preliminary objection? First of all, you have to look at whether this, you have to consider or look out for certain things which I'll list out now, which are whether the suit was instituted by the right mode. Was it supposed to be by writ of summons and is by the originating summons? You have to consider whether the proper parties are before the court. You have to consider whether there is a condition precedent that was not satisfied. I mean, like issue of a serving of a pre-action notice. If a pre-action notice ought to be served and it was not served, you can use that as a ground for a preliminary objection. You have to look at issue of jurisdiction. You know that without jurisdiction, whatever the court is doing is a nullity. Jurisdiction is the live wire of adjudication. Now, you have to look out for proper court. Is it the suit supposed to be in the court that it has been filed in? Is it a national industrial court matter and is it in the high court? Is it a federal high court matter and is in the state high court? These are things you have to consider and you can use them as a ground in your preliminary objection. Now, very important is the issue of filing and service. Was the originating process properly filed and served? Now, was it signed by a legal practitioner? Issue of service has to be personal, but if personal service is not possible, you do substituted service. Now, before even a substituted service is carried out, you have to get the order of courts authorizing you to proceed by way of substituted service. So if these things are not in place, then you can use them as a ground to raise your preliminary objection. Another very important thing is issue of signing of the writ. So we call it issuing of the writ. Sometimes you see where writs are issued by a law firm, we ought not to be. It has to be issued by a legal practitioner. So you have to check out this thing very, very well. Sometimes, look, you see lots of preliminary objections are based on this point. A suit is beautiful, wonderful, but it was not properly issued. The writ was not properly issued. So you have to look out for this as a defendant counsel. You can use these points to raise a preliminary objection. Now, a preliminary objection can be by way of a motion, like a normal motion, but in the prayers to now seek the court to either strike out the suit or dismiss the suit based on the grounds you are going to raise. You can also head it as a preliminary objection. Then you now bring the rule upon which you're relying on, then file your affidavit and a written address, and you argue it in court. Sometimes matters end at the point of preliminary objection. Once the preliminary objection is taken and the court gives its ruling, either sometimes it is upheld by the suit is struck out or is dismissed, or some other time it fails and parties proceed on the full hearing. So as a defendant counsel, you have to look out for these small, I call it small things, but they are heavy. You can use them as a point for your preliminary objection. So you have to look at issue of jurisdiction and say proper parties, mode of commencement, condition precedent, whether it has been satisfied, issue of a local standing, was there a reasonable cause of action. So all these you have to look out for them and you can use them to file your preliminary objection. So in this channel, I always emphasize on excellence. You have to be a smart lawyer and excellent lawyer. Thank you for watching this channel. Thank you for subscribing to this channel. Thank you for sharing this video. Thank you for liking this video. I'm here to give you how it ought to be. Thank you for watching.